Imagine you're standing in a court of law. For 30 years, this specific court has been the graveyard of the Second Amendment. They have found every creative legal loophole imaginable to tell you that your rights don't exist, that your property is illegal, and that your self-defense is a crime. I'm talking, of course, about the Ninth Circuit Court of Appeals, but something just happened that has sent a shockwave through the legal world. A single mother in Los Angeles just did something that could change gun laws across America forever. She got arrested for carrying a firearm to protect herself, refused to back down, and forced a federal court to admit what we've known all along: the government has been violating your constitutional rights for decades. In a decision that literally has anti-gun politicians in California, New Jersey, and Hawaii scrambling, the Ninth Circuit just ruled that the system is officially broken and that you no longer have to play by its rigged rules to fight for your freedom. If you were arrested for carrying a firearm before the landmark Bruen decision, or if you live in a state where getting a permit is a bureaucratic nightmare designed to make you give up, this video is the most important thing you will watch all year. We are talking about the futility doctrine, the collapse of the Los Angeles permit scheme, and a legal precedent that could overturn thousands of criminal convictions across the country. Stay tuned, because the Second Amendment just got its biggest win since 2022, and it happened in the one place nobody saw coming. To understand why this is a legal earthquake, you have to understand the geography of the battlefield. The Ninth Circuit covers the entire West Coast and beyond: California, Oregon, Washington, Hawaii, Alaska, Montana, Idaho, Nevada, and Arizona. Every gun owner in these 9 states has lived under the shadow of the nation's most hostile federal appeals court for constitutional carry rights. For decades, it has been the most hostile federal court in America for gun owners. The statistics tell a story that every gun owner needs to understand. We're talking about a court that has ruled against the Second Amendment in over 85% of cases since the 1990s. That's not a court applying neutral legal principles. That's a court with an agenda. Whenever a pro-gun ruling managed to squeak through a small 3-judge panel, the full court would immediately step in, use what's called an en banc review, and crush the ruling into dust. But the Supreme Court's 2022 Bruen decision changed the math. Justice Thomas made it clear: no more interest balancing, no more public safety excuses. If a law doesn't have a historical analog from the founding era, it's unconstitutional, which makes what just happened absolutely stunning. A federal appeals panel just ruled that people arrested for carrying firearms before the Supreme Court's Bruen decision in June 2022 can challenge their arrests in federal court, even if those arrests were considered legal at the time. The court acknowledged what Second Amendment advocates have been saying for years: laws that make it virtually impossible to get a carry permit violate the Constitution, and people shouldn't be punished for exercising rights the government had no authority to restrict in the first place. This wasn't a narrow, technical ruling buried in legal footnotes. This was a federal court admitting that state and local governments have been systematically violating constitutional rights, and that the people who were arrested under these unconstitutional schemes deserve their day in court. Enter the case of Matthews versus City of Los Angeles. This case involved ordinary Americans, including our single mother who became the face of this fight. These weren't activists with million-dollar legal teams at the start. They were people who chose to carry firearms for self-defense in Los Angeles, a city where, for years, getting a permit was statistically impossible unless you were a judge, a celebrity, or a retired cop. The plaintiff didn't have political connections. She wasn't wealthy. She wasn't a test case carefully constructed by a national gun rights organization. She was an ordinary American who made a decision that millions of people across this country make every single day. She chose to prioritize her physical safety over a government permission slip that she had virtually no chance of obtaining. Los Angeles County's concealed carry permit system before Bruen was a masterclass in constitutional evasion. The approval rate for ordinary citizens hovered around 2%. Let me say that again, less than 2%. The waiting time stretched beyond 18 months. The fees exceeded $400. And the people who actually got permits? Retired law enforcement, judges, celebrities, wealthy donors, and politically connected insiders who could demonstrate specific, documented threats to their safety. If you were a single mother working 2 jobs in a dangerous neighborhood, your need for self-protection didn't matter. If you were a small business owner making late-night bank deposits in a high-crime area, your concerns were irrelevant. The system wasn't designed to protect the people who needed protection most. It was designed to ensure that only the right kind of people could exercise their Second Amendment rights. These ordinary Americans looked at that system and made a choice. They got arrested. They were processed. They were treated like criminals for exercising a right that the Supreme Court later affirmed was fundamental, and they just convinced the Ninth Circuit that their arrests violated clearly established constitutional rights. The city of Los Angeles thought they had a slam dunk. They argued that because these individuals were arrested before the Bruen decision, and because they didn't even bother applying for a permit they knew they'd never get, they didn't have standing to sue. Essentially, the government's argument was, you didn't ask for our permission to use your rights, so you can't complain that we took them away. The Ninth Circuit just looked at that argument and called it what it is, constitutional nonsense. But here's what makes this ruling absolutely explosive for gun owners across America. The legal principle the court just established doesn't stop at the California border. The Ninth Circuit didn't just rule on a single case. They established a legal framework that Second Amendment attorneys are already using as a blueprint to challenge restrictive carry laws in every remaining may-issue state in America. This brings us to the core of this victory, the futility doctrine. For years, anti-gun states have used administrative exhaustion as a weapon. They create a permit system so complex, so expensive, and so slow that it takes years to get a no. They require 16 hours of training, $500 in fees, psychological exams, and character references from your third-grade teacher. If you wanted to challenge that system in federal court, judges would usually say, "Sorry, you haven't been harmed yet. You need to apply for the permit, wait 18 months for the denial, appeal the denial, wait another year, and then you can come talk to us. It was a trap. By the time you got to court, you were broke, and the law might have already changed." The Ninth Circuit's new ruling in Matthews changes the game. The court established that if a system is obviously rigged, if applying is a futile gesture, you don't have to waste your time or money. You can skip the line and go straight to the lawsuit. The court literally said, a plaintiff need not apply for a benefit before filing suit if doing so would be futile. Think about what that means for a second. This doesn't just apply to Los Angeles. This applies to Hawaii, where permits are virtually non-existent. It applies to Maryland's high fee structure. It applies to New York's sensitive places maps that make a permit useless. If the government makes the hoop impossible to jump through, the Ninth Circuit says you don't have to jump. You can just sue to tear the hoop down. The core of the ruling centers on something called qualified immunity and clearly established law. For years, government officials who arrested people for carrying firearms hid behind a legal shield. They claimed that because the Supreme Court hadn't explicitly ruled that may-issue permit schemes were unconstitutional, they couldn't have known they were violating anyone's rights when they made arrests. This is the same circular logic that has protected government misconduct for decades. The reasoning goes like this. We can violate your rights as long as no court has specifically told us that this exact violation is unconstitutional. And since we keep arresting people before courts can rule on the issue, we'll never be held accountable. The Ninth Circuit just demolished that argument. The court ruled that after the Supreme Court's decisions in Heller and McDonald, which recognized that the Second Amendment protects an individual right to bear arms for self-defense, it was clearly established that people have a constitutional right to carry firearms for self-protection. The fact that some states continued to operate permit schemes that made exercising that right virtually impossible doesn't mean the right didn't exist. It means those states were violating clearly established constitutional law. We often talk about precedent and doctrines, but law is about people. The individuals in this case, including our single mother from Los Angeles, did something incredibly brave. They knew the risks. They knew that carrying without a permission slip in LA could lead to jail time, a criminal record, and the loss of their rights forever. But they also knew that their rights didn't come from the LA Board of Police Commissioners. The city tried to paint them as unlicensed, as if they were driving without a license. But the Second Amendment isn't a driving privilege. It's a right. The Ninth Circuit panel noted that these plaintiffs plausibly alleged that at the time of their arrests, LA had what amounted to a no-issue policy for anyone who wasn't a judge or a cop. Under Bruen, no issue or may issue, where the police decide if you're worthy, is dead. The court's logic was simple but devastating. If the city's policy was unconstitutional when these individuals were arrested, then the arrests themselves were an injury. This is the legal earthquake the media isn't telling you about. The court is saying that the Constitution didn't start being the law in June 2022 when Bruen was decided. It has always been the law, and if the government was violating it in 2019 or 2020, they are liable for those violations today. Now, you might be thinking, if this is so obvious, why did it take years to get this ruling? The answer lies in what I call the district court betrayal. Before this case reached the Ninth Circuit, it sat on the desk of a federal district judge who did everything in his power to ensure these gun owners never saw the light of justice. Judge Manuel Real dismissed the lawsuit with a flick of his pen. He didn't just rule against them, he insulted the very concept of constitutional protection. He argued that because these individuals were arrested before the Supreme Court's Bruen decision in June 2022, they had no right to complain. Think about the twisted logic there. The judge was essentially saying that an unconstitutional law is perfectly valid until the very second the Supreme Court strikes it down. This is what we call the retroactivity trap. It's a favorite tactic of anti-gun judges. They want to create a world where the government can violate your rights for 50 years, and even if they lose in court on year 51, they get a free pass for everything they did before that. The district court went even further. They claimed that because these plaintiffs didn't participate in the rigged permit system, meaning they didn't pay the $400, wait the 18 months, and get the inevitable denial, they couldn't prove they were harmed. The Ninth Circuit just shredded that logic. They compared it to a First Amendment violation. Imagine if a city had a law saying you need a permit to speak in public, but they only gave permits to people who donated to the mayor's campaign. If you went out and spoke without a permit and got arrested, would a judge tell you, well, you didn't apply for the corrupt permit so you can't sue for free speech? Of course not. That would be insane. And yet, that is exactly how the Second Amendment has been treated as a second-class right until this very ruling. Think about how we would react if states imposed similar barriers on other constitutional rights. Imagine if you had to pay $400, wait 18 months and prove good moral character to a government bureaucrat before you could vote. Or if you needed a permit that cost $300 and required 16 hours of government-approved training before you could attend a church service. Or if you had to demonstrate urgency or need and wait 2 years for approval before you could hire an attorney to defend yourself in court. The public outcry would be immediate and overwhelming. We would instantly recognize these requirements as unconstitutional poll taxes, religious tests, and denials of due process. We wouldn't tolerate bureaucrats having unlimited discretion to grant or deny fundamental rights based on subjective evaluations of our character or need. This leads us to the most explosive part of the ruling, retroactivity. The Ninth Circuit clarified that when the Supreme Court decides a case like Bruen, it isn't making a new law, it is declaring what the law has always been. This is a massive distinction. If Bruen just made a new law, then everyone arrested before 2022 is out of luck. But since Bruen was a clarification of the original intent of the Second Amendment, it means that the May issue schemes in California, New York, and Hawaii were always unconstitutional. They were unconstitutional in 2010. They were unconstitutional in 2020. The Ninth Circuit panel was very clear. The government cannot hide behind the fact that they thought their unconstitutional laws were okay because a lower court hadn't stopped them yet. This creates a legal avalanche. In Los Angeles alone, how many thousands of people were stopped, searched, and arrested for carrying a tool of self-defense without a good moral character permit? How many people had their lives ruined, lost their jobs, or spent time in a cell because they refused to wait for a permission slip that was never coming? This ruling means that those arrests were based on a nullity. In the eyes of the law, an unconstitutional statute is as if it never existed. This isn't just a win for the plaintiffs in this case, it is a get-out-of-jail-free card potentially for thousands of people who are currently caught in the gears of the system. This matters for 3 critical reasons that every gun owner needs to understand. First, it means that people who were arrested for carrying firearms in May-issue states before Bruen now have a viable legal claim in federal court. Thousands of Americans who were criminalized for exercising their constitutional rights may be able to challenge their convictions, have their records expunged, and potentially receive compensation for the violation of their civil rights. Second, it means that the officials who made those arrests, the prosecutors who pursued those cases, and the jurisdictions that maintained unconstitutional permit schemes could face significant financial liability. Federal civil rights lawsuits under Section 1983 allow individuals to sue government officials who violate constitutional rights under color of law. Third, and perhaps most importantly for the future of gun rights in America, it means that restrictive states can no longer hide behind the claim that their permit schemes are constitutional just because courts haven't specifically struck them down yet. The legal standard has shifted, the burden of proof has changed, and the excuses that anti-gun jurisdictions have relied on for decades are no longer available. But this is where it gets even more intense. This isn't just about individuals getting their records cleared. This ruling just opened the door for a massive wave of civil rights lawsuits under Section 1983. We are talking about potential millions of dollars in liability for cities that spent decades arresting law-abiding citizens under illegal laws. In the legal world, there is a tool called 42 U.S. Code Section 1983. It is often referred to as the Civil Rights Act, and it allows individuals to sue government officials who, under the color of law, deprive them of their constitutional rights. Until now, Section 1983 was rarely used successfully in Second Amendment cases because courts were so protective of qualified immunity for police and bureaucrats. But the Ninth Circuit just changed the math. By ruling that these pre-Bruen arrests were a violation of a fundamental right, they have opened the floodgates for monetary damages. Think about the liability here. If you were wrongfully arrested, you didn't just lose a day in jail, you lost your job, you paid thousands in legal fees, you suffered the stigma of a criminal record. Under Section 1983, the government could be on the hook for compensatory damages, paying you back for every cent you lost. Punitive damages, extra fines to punish the city for their intentional right suppression, and attorney's fees. This is the big one. The city has to pay your lawyers. Legal scholars estimate that over 15,000 people have been arrested for unlawful carry violations in May-issue states since the Supreme Court's McDonnell decision in 2010. Conviction rates in these cases exceeded 90%, largely because defendants couldn't afford the massive expense of challenging obviously unconstitutional laws in federal court while simultaneously fighting criminal charges in state court. If even 10% of those 15,000 people file suit, we are talking about billions of dollars in potential settlements. This isn't just a legal win, it's a financial gun to the head of every anti-gun city council in America. They can no longer afford to be unconstitutional. Let's look at what this ruling does to the remaining anti-gun states. Even after Bruen, states like Hawaii and Maryland didn't just give up. They pivoted. They said, okay, we'll give you a permit, but first you have to prove you have good moral character. And by the way, we get to define what that means. They use subjective standards to keep the rejection rates high. They look at your social media, they interview your neighbors, and they look for any excuse to say no. The Ninth Circuit's embrace of the futility doctrine just put those states on notice. Within 72 hours of this decision being published, Second Amendment legal teams in 4 different states confirmed they're preparing federal lawsuits using the exact legal framework established in this Ninth Circuit case. The targets aren't just carry permit schemes. They're the entire infrastructure of gun control measures designed to make exercising Second Amendment rights so expensive, time-consuming, and bureaucratically complex that ordinary Americans simply give up. Hawaii currently has fewer than 200 active concealed carry permits for a population of 1.4 million people. That's a permit rate of 0.014%. To put that in perspective, you have a better statistical chance of being struck by lightning in your lifetime than getting a carry permit in Hawaii if you're not politically connected. The state's permit process requires applicants to demonstrate the urgency or need to carry a firearm, show good moral character, complete a firearm safety course, provide fingerprints, submit to a background check, and obtain approval from the chief of police, who has unlimited discretion to deny applications for virtually any reason. The fees total more than $350, and the processing time can exceed 2 years. If a state's good moral character requirement is being used as a de facto ban, meaning they are rejecting 98% of people, you no longer have to wait for your own rejection letter to sue them. You can use the statistical evidence of their corruption to get into federal court. The court pointed out that you don't need a PhD in math to see that the system is rigged. This ruling gives attorneys a fast pass. They can walk into court and say, look at the numbers. Applying is futile. Strike the law down now. This is how we force every anti-gun state to finally follow the Constitution. Maryland faces similar exposure. The state requires 16 hours of firearms training, multiple fees totaling over $300, fingerprinting, background checks, and a good and substantial reason to carry a handgun. Even after Bruen supposedly eliminated subjective approval standards, Maryland simply rebranded its restrictions and continued operating essentially the same system under different legal terminology. Massachusetts grants local police chiefs near-total discretion to determine who receives a license to carry. Chiefs can impose additional training requirements beyond the state minimum, deny applications based on subjective suitability determinations, and restrict licenses to specific purposes that effectively prohibit carrying for general self-defense. The result is a patchwork system where your ability to exercise constitutional rights depends entirely on which town you happen to live in. New Jersey's permit process is so restrictive that the state issues fewer than 1,000 permits annually to a population of 9 million people. Applicants must provide references, submit to extensive interviews, justify their need to carry, and wait months or even years for approval that typically never comes. These aren't hypothetical future targets. These are active legal challenges being prepared right now, and they're all built on the foundation that this Ninth Circuit case just established. We are moving away from may issue, where they choose, and shall issue, where they must, and moving toward a world where the government is terrified of the financial and legal consequences of denying your rights. This ruling is already traveling east. Within 48 hours of the Ninth Circuit's decision, legal teams in Maryland, Massachusetts, and New Jersey were already citing the Matthews case in their own filings. The futility doctrine is the silver bullet for these schemes. Attorneys no longer have to wait for a specific client to be rejected. They can take the Ninth Circuit's logic and argue that the entire structure of the law is designed to discourage the exercise of the right. So, what is the bottom line for the average gun owner watching this? If you're a gun owner in a restrictive state, This ruling changes your legal landscape in three immediate ways. First, if you were arrested or convicted for carrying a firearm without a permit in a May-issue state before the Bruen decision in June 2022, you may have grounds for post-conviction relief. This doesn't mean every conviction will be automatically overturned, but it does mean you have a viable legal argument that your constitutional rights were violated and that your conviction should be expunged. You need to contact a Second Amendment attorney immediately. Your conviction might be eligible for vacatur, meaning it's wiped from your record, and you might be entitled to compensation. Second, if you're currently navigating a permit process in a restrictive state and facing denials, excessive delays, or arbitrary requirements, you now have stronger legal grounds to challenge those obstacles in federal court. If you live in a restrictive state and you've been waiting to apply because the system is too expensive or too slow, this ruling is your green light to support legal challenges. You are no longer a victim of the wait. You are a citizen whose rights are being actively suppressed, and the courts are finally starting to agree with you. Third, if you're considering whether to carry for self-defense despite living in a restrictive jurisdiction, this ruling doesn't give you legal permission to violate current state law, but it does establish that the legal and constitutional landscape is shifting rapidly. The laws you're subject to today may be recognized as unconstitutional tomorrow, and the arrests being made under those laws may eventually be acknowledged as civil rights violations. The tide is turning. For 30 years, we were told the Ninth Circuit was a lost cause. We were told that the Second Amendment was a lesser right. This ruling proves that even the most hostile courts can't ignore the Supreme Court forever. The legal earthquake isn't just starting, it's accelerating. One person, an ordinary single mother who refused to accept a government permission slip for a right she was born with, just changed the legal landscape for millions of Americans. Because of her courage, and because she was willing to face the rigged game head-on, millions of Americans are safer today. But remember, the price of freedom is eternal vigilance. The anti-gun states won't stop. They will just try to find new, even more creative ways to ignore this ruling. That is why you need to stay informed, stay engaged, and most importantly, stay armed. This legal avalanche is just beginning, and you cannot afford to miss what happens next. This is a win for the Constitution, this is a win for common sense, and most of all, this is a win for you. Stay informed, stay armed, and stay free.